Hi, my name is Yogya Bhatia and I'm a legal intern at LEXIS and Company. Today I'll be talking about abetment. Laws keep checks on human behavior. It categorizes them into criminal and non-criminal behaviors. However, every non-criminal behavior, even something as simple as bullying or buying a knife for your kitchen, becomes criminal when there are criminal intentions behind it. The concept of abetment widens the horizon of criminal law to incorporate these criminal intentions and penalize them even when the person who bought the knife did not actually kill anyone but handed it over to someone else to do it. To explain the concept of abetment, the word abet should be given a deep scrutiny. In general use, it means to aid, advance, assist, help, and promote. In the case of Sanju versus State of Madhya Pradesh, the Honorable Supreme Court defined abet as meaning to aid, to assist, or to give aid, to command, or to procure, or to counsel, to continuance, to encourage, or to set another one to commit. The definition of abet as laid down makes it clear that abetment only occurs when there are at least two persons involved, which further directs us towards the arrangement and operations of the act. In usual parlance, a person is held to be liable only if he or she has personally committed a crime. Detouring from the usual concept, the concept of abetment says that he who has helped the criminal or provided him with any assistance in any form can also be held liable. This article will discuss at length the nitty-gritty of abetment laws in India. Meaning of abetment. In a common parlance, the word abet signifies help, co-activity and support and incorporates within its ambit illegitimate reason to commit the crime, so as to bring an individual abetting the doing of a thing under any of the conditions specified under Section 107 of the Indian Penal Code. It isn't just important to demonstrate that the individual who has abetted has participated in the means of the transaction, yet additionally has been associated with those means of the transaction which are criminal. Abetment under the IPC. Abetment is constituted by instigating a person to commit an offence or engaging in a conspiracy to commit it or intentionally aiding a person to commit. The offence of abetment by instigation relies on the intention of the individual who abets and not upon the act which is finished by the individual who has abetted. The abetment might be by instigation, convenience, or purposeful aid as given under Section 107 of the Indian Penal Code. However, the words are articulated in an angry state or omission without any intention cannot be termed as instigation. For an individual to be called liable for abetment and so as to proceed against an individual for a criminal offence under Section 107, prosecution must claim the component of mens rea. Negligence or carelessness can't be named to be abetment in order to punish the liable according to the arrangement of penal laws. So as to establish abetment, the abettor must have appeared to deliberately support the commission of the wrongdoing. In such a case, we need to just prove that the wrongdoing charge couldn't have done without the association as well as intervention of the supposed abettor is insufficient with the prerequisites of Section 107. When we talk about a sting operation which is typically carried out in public interest, it must be noted that the same is done by instigating the accused. Thus, the person in question, who is generally honest, is tricking into carrying out a wrongdoing on the confirmation of secrecy and confidentiality of the transaction, bringing up the potential issue with respect to how such a victim can be considered in charge of wrongdoing, which he could not have done had he had not been given the assurance. In such conditions, should the individual, that is, the sting administrator, be held criminally liable for commission of the offence? This is a bewildering question when there is a claim that the sting administrator is asserted to have committed the abetment of the offence. The Supreme Court in Rajat Prasad vs. CBI saw that the wrongdoing does not stand crushed or exonerated just in light of the fact that its benefit extends to the general public at large. Suppose an individual failed to prevent an offence from taking place, so the inquiry emerges as to whether the failure will add up to abetment or not. This situation of law later has been attested by the Supreme Court, which anyway held that even though he isn't an accomplice, the court would even now need proof on material specification as he is the main observer of the wrongdoing, and it is dangerous to hang the accused on his sole declaration, except if the court feels persuaded that he is talking in reality. Such confirmation need not be that as it may on the subject of the actual commission of the offence. What the law requires is that there ought to be such support of the material piece of the story connecting the person who is blamed with the wrongdoing as will assure a reasonable man that the man cannot be viewed as an honest person and his statement cannot be relied upon. Often, abetment may also consist of passive assistance. For example, in a case where the accused was found with a spare on the scene of the flight, his participation in the fight was proved. It was immaterial whether or not they actually made use of their weapons. They were still held liable for the injuries caused to the defendant party. In case of Tuck v. Robson, a publican, by not making any effort to make his customer leave the premises after the pub was closed, was said to have aided the crime of abetment of consumption of the liquor after the hours in which it was permitted. Similarly, let's talk of a situation wherein an owner of a car who was not driving on the particular instance had entrusted the task of driving the car to his friend that day. The friend was involved in driving in a very absurd manner, and the owner of the car was charged with abetment because he had failed to stop the driver from indulging in such driving. Thank you.